Welcome to the Supreme Court of the United Kingdom, where today we're hearing the second day of an appeal brought by the Secretary of State for Health in proceedings brought by the Secretary of State against a pharmaceutical company, Servier Laboratories Ltd. The appeal is concerned with the ingredients of the tort of causing loss by unlawful means, and in particular, what was decided in that regard by the House of Lords in a case called OBG some years ago, and whether that decision was correct. We're currently hearing submissions on behalf of Servier Laboratories, presented by the senior counsel, Ms. Marie Dimitriou, Queen's Counsel. So I'll invite Ms. Dimitriou now to resume her submission.
Thank you, my lord. May I please pick up where I left off yesterday, which is the OBG judgment, and in particular the speech of Lord Hoffman. And could I ask your lordships please to turn up page 595 of the bundle. And I just want to come back, before proceeding in the judgment, to a question put to me yesterday afternoon by Lord Sales in relation to paragraph 47. And Lord Sales asked me to comment on paragraph 47, which appears to be addressed in quite general terms. And I would just like briefly to expand upon my answer and to say this, which is that what in my submission Lord Hoffman's doing in paragraph 47 is indeed describing the tort at a high level of generality. And he then proceeds in the remainder of this section of the judgment to expand upon and explain each of the elements which he has summarised at a high level of generality in paragraph 47. And so it's a structural point. You see that he says the first point is that the essence of the tort appears to be a wrongful interference with the actions of a third party. So pausing there, over the page, you see paragraphs 48 to 50 are dealing with wrongful interference, and they're going into more detail about actionability. And then you have the point about economic interest. And what paragraphs 51 to 55 are doing are giving meaning to the concept of economic interest. They're saying that economic interest has a specific meaning, which is concerned with dealings. And then you see at 56 to 60 of the judgment on page 598 that Lord Hoffman's there explaining why no other control mechanism works. And then he goes on from paragraph 62 to look at intention. So really my answer to Lord Sales is that he's not purporting comprehensively to state the tort in paragraph 47. He is precisely explaining it at a high level of generality, which he then unpacks in the following sections of the judgment. And going back to where I left off yesterday, we see at paragraph 58, so I had dealt with 51, and just dwelling on 51 for another moment on page 596. And again, to come back to an observation made by Lord Reid yesterday, the first sentence of 51 talks about interfering with the freedom of a third party. And then you see in the last sentence what he means by that. So he gives meaning to that particular concept. And then you have the sections at 52 to 55 where he explains how in other cases have failed because of the absence of this dealing requirement, this mechanism. And then you see at paragraph 58 on page 598, Lord Hoffman there saying that it's not enough, he says, it's not sufficient to say that there must be a causal connection between the wrongful nature of the conduct and the loss. If a trader secures a competitive advantage over another trader by marketing a product which infringes someone else's patent, there is a causal relationship between the wrongful act and the loss which the rival suffered, but there's surely no doubt that such conduct is actionable only by the patentee. So he's saying factual causation in itself is not enough to ensure the requisite proximity. And then you see at 59 and 60, paragraphs 59 and 60, Lord Hoffmann saying, nor in his view is intention a sufficient tool by itself to constrain the tort appropriately. And you see at 59 the reference to an article by Lord Sales and Daniel Stillitz, which takes a wider view as to the nature of the unlawful act, and says that in their view that should be counterbalanced by a specific intention to target the claimant. And then you see other writers consider it would be arbitrary and illogical to make liability depend on whether the defendant has done something which is wrongful for reasons which have nothing to do with the damage inflicted on the claimant. And so what Lord Hoffmann's recognising there in the last few sentences of that paragraph in my submission is an aspect of remoteness. And it may be useful to think about remoteness in two different ways. So one way is the way he's already referred to in the passage of Lord Lindley, which is indeterminate liability. So you don't want claims which are, for example, so far down the causation that that's going to result in indeterminate liability. But another way, another aspect of remoteness is remarked on here in paragraph 59, and that's the lack of a logical connection between the unlawful act, the reason why the act is unlawful, and the loss. And then at paragraph 60, what Lord Hoffmann is saying is that he doesn't think that the width of the concept of unlawful means can be counteracted by insisting on a highly specific intention which targets the plaintiff. That, as it seems to me, he says, places too much of a strain on the concept of intention. In cases in which there's obviously no reason why a claimant should be entitled to rely on the infringement of a third party's rights, courts are driven to refusing relief on the basis of an artificially narrow meaning of intention, which causes trouble in later cases in which the defendant really has used unlawful means. And so he's considering, but rejecting, the notion of using a more precise version of intention in order to guard against remote cases. And what he has, of course, instead is the dealing requirement, which does that job. And of course, the reason why, paragraph 61. Paragraph 61 is also important when it comes to discerning the ratio, because he says, in defining the tort of causing loss by unlawful means as a tort which requires interference with the actions of a third party in relation to the plaintiff, I don't intend to say anything about the question of whether a claimant who's been compelled by unlawful intimidation to act to his own detriment can sue for his loss. So that's the two-party situation. But it's the first words that are important, because he's saying he's defining the tort in a way which requires interference. So the unlawful act needs to interfere with the actions of a third party which relate to the claimant. So that's relation, dealing with the claimant. Not simply which, as a matter of fact, cause the claimant loss. And he's saying that that is part of the definition of the tort. And that's why we say, that's one of the reasons why we say it simply isn't sustainable to argue that the dealing requirement, the requirement of a relationship that is specifically attacked or affected, a relationship between the third party and the claimant that's specifically attacked or affected, why it's not sustainable to say that that isn't part of the ratio of these judgments. Now, moving on to the disposal of the case, and could I ask the court please to turn to page 614. Of course, the reason why the tort did not apply on the facts of this case was precisely the absence of any effect on the dealings between the third party, the Douglases, and the claimant, OK Magazine. And we see that from paragraph 129 of the judgment, which you've already looked at. And So that's the reason why the tort was held not to apply. And then you see paragraphs 130 and 134 to 135. What Lord Hoffman is doing here is saying, again, he returns to the question of intention, and he says that he doesn't consider that intention can fulfill the role of the necessary control mechanism. So that had been the approach we see from paragraph 130 that the Court of Appeal had adopted. And essentially what Lord Hoffman says is that that's really highly artificial, because it's open to anyone to say, well, I didn't really want to cause my competitor loss. What I wanted to do was advance my own interests. That's almost always going to be the case, unless there's some specific animus, evidence of animus towards the competitor. But what he's saying is that, and we see that from paragraph 134, at the bottom of page 615. So you see there that the position of Mr. Junco was that he wished to defend his publication against the damage it might suffer on account of having lost the exclusive. But that, it seems to me, is precisely the position of every competitor who steps over the line and uses unlawful means. The injury which he inflicted on OK in order to achieve the end of keeping up his sales was simply the other side of the coin. His position was no different from Mr. Guy, saying that he had no wish to injure Mr. Lumley and had the greatest respect for Her Majesty's Theatre, but his intention was to improve attendance at his own theatre, or the Master of the Othello, saying that his intention was to buy more palm oil. And so what Lord Hoffman does there is endorse Sorrell and Smith intention, the other side of the coin intention. And at 135, he's expressly rejecting a narrower version of intention as being the control mechanism to restrict the ambit of the tort. You see that in terms said expressly. And the reason he does that is because the reason he doesn't like more specific intention is that he thinks would arbitrarily confine the tort too narrowly. So he says that the effect is to enable virtually anyone who really has used unlawful means against a third party in order to injure the plaintiff to say that he intended only to enrich himself or protect himself for loss. So that's not the way to keep the tort within reasonable bounds. The way to keep the tort within reasonable bounds is the dealing requirement. And we see just now, turning to the other speeches in the judgment, Lord Walker's judgment is also important. And could I ask the court please to pick up the report at page 638. And what we see at paragraph 266 in Lord Walker's speech is an express recognition on his part that the important difference between Lord Hoffman and Lord Nichols was in relation to the control mechanism needed to stop the tort getting out of hand. So we see that at 266, that's what he says. The most important difference is the identification of the control mechanism needed in order to stop the notion of unlawful means getting out of hand. And then we see Lord Hoffman sees the rationale of the unlawful means tort as encapsulated in Lord Lindley's reference in Quinn and Leatham to interference with a person's liberty or right to deal with others. And so that's the touchstone, that's the control mechanism that Lord Hoffman relies on, as Lord Walker sees it, and as Lord Hoffman himself has said, as I've shown you. And then you see over the page at page 268, by contrast, Lord Nichols proposes a wider test of unlawful means, relying on the notion of instrumentality as the appropriate control mechanism. So there's a debate between the two, between Lord Hoffman and Lord Nichols, as to what is the appropriate control mechanism. That's how Lord Walker sees it, and that is the reality of the judgment. So it can't be said that Lord Hoffman's approach to Lord Hoffman's reference to the dealing requirement is simply an obiter add-on. It really goes to the controllability, the manner in which he saw the tort as being controlled. And then we have, of course, Lord Walker's own conclusion at 269, and he prefers, it's fair to say, accepts that this might not be the last word, but he prefers Lord Hoffman's approach, And he says, you can see that the control mechanism must be found, it seems to me, in the nature of the disruption caused as between the third party and the claimant by the defendant's wrong, and not, so causation by itself is not enough. Now, turning to Lady Hale's speech, and if I could ask you please to pick it up at page 650, the bottom of page 650. And you see in the middle of that paragraph, paragraph 306, you see this, that nevertheless the common thread is striking through a third party who might otherwise be doing business with your target, whether by buying his goods, hiring his barges, or working for him, or whatever. The refinement proposed by my noble and learned friend Lord Hoffman is entirely consistent with the underlying principles to be deduced from the decided cases. It's also consistent with legal policy to limit rather than to encourage the expansion of liability in this area. And Lady Hale then says such matters are better left to Parliament. That the common law, this is the top of page 651, need do no more than draw the lines that it might be expected to draw, procuring an actionable wrong between the third party and the target, or committing an actionable, in the sense explained by Lord Hoffman, wrong against the third party, inhibiting his freedom to trade with the target. So again, it can't be said that this is some bolt-on which nobody focused on, because here Lady Hale's saying, well, this is the means by which the tort is limited, and essentially it's a policy question. And then finally we have Lord Brown at page 655, at the bottom of page 655, under the heading causing loss by unlawful means, paragraph 320. And you see there, as he accepts Lord Hoffman's exposition, he agrees with his judgment, and he says that liability for the tort arises where the defendant, generally to advance his own purposes, intentionally injures the claimant's economic interest by unlawfully interfering with the third party's freedom to deal with him. And then you see, to define a bit further down on page 656, still in the same paragraph at the top of the page, to define and circumscribe the tort in this way seems to be not only faithful to its origins, as described by Lord Lindley, and consistent with the great bulk of authority which has considered the tort over the ensuing century, but also to confine it to manageable and readily comprehensible limits. So again, Lord Brown is also going into this with his eyes open, unsurprisingly. So it's a requirement which was specifically considered by all in the majority, and which they all considered served an important function. So it's not right, it's simply not right on the face of the judgment to say, as my learned friend does, that it's an arbitrary requirement that serves no function at all. Now, Mr. Crowe made the point in addressing the question of ratio. He made the point that Deakin and Randall's view is that the entire OBG judgment on the unlawful means tort is obiter because the case succeeded on breach of confidence. Now, Mr. Crowe rather tantalisingly offered that as a possible course to your lordships if you were attracted to it. It wasn't clear to me whether he was positively making the submission that that is right, but if he was making that submission, we say, of course, the consequence of the submission would be that my lords could depart from OBG without the requirements of the practice statement being satisfied. And we say that that would be wrong. First, because the very purpose of this judgment was to organise and rationalise the tort following very lengthy and substantial argument over 11 days and a comprehensive survey of the authorities and the academic literature. And it would defeat that purpose to find that the whole of it is obiter and therefore doesn't require good justification for departing from it. And secondly, we say that the judgment held, so the House of Lords held that the tort was not open to the claimants, and they reach that conclusion on a fully reasoned basis. And we say it's wrong in those circumstances to say that that conclusion is obiter simply because a different cause of action was available. Now, Mr. Crowe also argued that the court can treat the ratio as not including the dealing requirement, essentially because the case could have been decided on their weaker instrumentality basis as well. But the simple answer to that is that could have does not answer the question whether it was decided on that different basis, and it most plainly wasn't. And you see that really highlighted in the speech of Lord Hawker, who draws that precise distinction between the approach of the majority and the approach of Lord Nichols. And indeed, it's a point that if you could perhaps just turn up our written case at page 90.
Are we leaving OBG?
We are leaving OBG. Does my lord have a question on OBG?
I'm just going to just go back, if I may, to page 596 and paragraph 50, where Lord Hoffman discusses Lonhro.
Yes.
And says it's arguably within the same principle as the National Phonograph. And he says that he goes on to say that Lord Justice Dillon rejected an argument that the means couldn't be unlawful because neither the directors nor the Secretary of State had suffered loss. That seems to be correct. The allegations were of fraudulent representations made to third parties, which were intended to induce the third parties to act in a way which caused loss to the plaintiff. Now, just thinking about Lonhro, I mean, on the fact, as I understand it, Hired had made a bid for Harrod in a situation where the bid had already been made by Lonhro and was still before the directors, but had been referred by the Secretary of State to the MMC.
That's right.
So, if the misrepresentations, if you look at the misrepresentations made to the directors, if they induce the directors to accept Fired's bid, then by the same token, they induce the directors not to accept the bid that was still before them by Lonhro.
Yes.
Now, so that would be an impact on the relationship between a business relationship between the directors and Lonhro. Now, as the Secretary of State, you can see it's a more difficult argument that Lonhro have to put up, because I suppose the argument would have to be, or post OBG, the argument would have to be that in a context where the Secretary of State had already made a reference of the Lonhro bid, effectively putting it on hold, for him not to treat the Fired bid the same way was plainly going to injure Lonhro. But it's difficult to bring it quite within the OBG terminology of or concept of affecting a dealing between the Secretary of State and Lonhro. But that's the one point in the case where Lord Wolfe indicated, or Lord Justice Wolfe indicated his doubts.
That's correct.
He didn't indicate a doubt about the case vis-a-vis the director. It was simply the Secretary of State.
That's right, and I was going to come back to Lonhro, but I agree that is the position. Of course, the short point in relation to what my learned friend says about Lonhro is that he needs to be able to establish that OBG is inconsistent with it, and he can't do that because the court didn't say that Lonhro's claim based on misrepresentations to the Secretary of State was sound in law. What the court said, on the contrary, and we'll come back to this, is that the law's in a very uncertain state and it's better to answer that question at trial.
Yeah, yeah. Yeah, yes, yeah. Yes, okay, thank you.
My Lord, so I was going to just, on the point about ratio, I was just going to turn to our written case at page 90, where at page 90 at paragraph 31, where we set out a passage from Lord Davies' speech in Allen and Flood, just because it's convenient to see it here. And so this really goes to the fallacy in Mr. Crow's argument that you can somehow treat the ratio in OBG as being, he says the case could have been decided on the basis of instrumentality. But what Lord Davies says is that it appears to me an obvious fallacy to argue backwards from the existence of some recognised and well-known cause of action to a larger and wider legal proposition of which the cause of action in question might be treated as a particular case if the larger proposition had been generally recognised. And we say that's the precise flaw in Mr. Crow's argument here. So the real question, to put it more shortly, is, well, what was the ratio? Not what could it have been, but what was it? Now, if the court is with me on the dealing requirement forming part of the ratio of OBG, then my learned friend's next argument is that even prior to the practice statement, it was open to the House of Lords to depart from a previous ruling if it was inconsistent, if that previous ruling was inconsistent with previous authorities. And my learned friend put forward two candidates. One was Allen and Flood, and the other was Lonhro, which we've just touched on. And could I start, please, with Allen and Flood? And before turning back to the report, what I'd like to do is just summarise the points I wish to make. So the first point is that in order to succeed on this argument, my learned friend needs to show that OBG is inconsistent not with dicta in Allen and Flood, but with its ratio. And the ratio of Allen and Flood is that intention cannot convert otherwise lawful means of causing harm into unlawful means. That's what the ratio was, and that's why the claim failed. And if I may respectfully suggest, my learned friend's efforts to seek to persuade the court to extract more than this from Allen and Flood were inconsistent, completely inconsistent, with his approach to the ratio of OBG, where he was seeking to persuade you to disregard the very reason why the claim in that case was said to fail. You can't have it both ways. Now, the second point I wish to make is that Allen and Flood was a dealings case. It was very plainly a dealings case. The representations complained of sought to interfere with the shipyard's dealings with the shipwrights whom they employed. So it follows that the court did not need to decide the question of whether a cause of action could be available in cases where there were no such dealings, because they plainly existed on the facts of that case. Now, Mr. Crow sought to identify parts of the judgment which describe the tort in broad terms without referring to interference with dealings, but we say it's not possible to derive from those passages a conclusion that the tort is available in a case where there's no interference with dealings, because the case simply wasn't dealing or wasn't addressing that. The third point I wish to make is that the dicta relied on by my learned friend don't actually establish what he needs them to. All on analysis, and I'm going to come to passages just to make this point good, but all that those dicta say is that interference with other types of relationship, in other words, non-economic relationships between the claimant and the third party, might also suffice to bring a claim. What they don't say is that there should be liability even where the unlawful means didn't interfere with any relationship between the third party and the claimant. So the dicta go to the type of relationship at most, which you need to show, not the existence of a relationship. Yet what the appellants need to show in this case is that there's no need for the interference to attack any type of relationship, because it's not that the EPO, the European Patent Office and the High Court didn't have economic dealings with the health authorities. They didn't have any dealings with the health authorities at all. That's the difficulty that my learned friend has to confront. Now, it may be in a future case that this court decides that the dealing requirement should extend to interferences with dealings between the claimant and the third party, which are not economic in nature. But that wouldn't detract from the control mechanism, and it wouldn't assist the appellants, and it's not an issue which arises in this case. So to explain that point, could I ask you please to pick up Allen and Flood and pick it up from page 439 and the speech of Lord Herschel. And in fact, we can see the context of this from the bottom part of page 438, and so that may be the better place to start. And the Lord Herschel there is looking at the facts of Garrett and Taylor, where the plaintiff was a mason and used to sell stones and employed workmen, and what the defendant committed a wrong against the workman, which injured the claimant because he was unable to obtain others. And of course here, what's being addressed generally, you'll bear in mind the context, is a different point to the point that's concerning this court. The question that's being addressed here generally is whether there's a general right to trade such that any intentional interference with it, even if otherwise lawful, gives rise to a claim. That's the target of this whole passage. It's not the question that's before this court. But in any event, what you see at page 439, the dicta relied on by Mr. Crowe, if the plaintiff had not been a tradesman, but the owner of a house, and the same menaces had been uttered to those who came from time to time to visit him, I cannot but think he would equally have had a cause of action. Again, in Tarleton and Macaulay, a gun was fired at a canoe. It said that the essence of the wrong was that the plaintiff was disturbed in his trade. I don't think so. Can it be doubted that if the ship owner had desired the presence of persons on board his ship for any other purpose, and the same wrongful act had deterred them from approaching the ship owner might have maintained a similar action to recover damages for any loss or inconvenience? So what's being envisaged here is that there shouldn't be a distinction between economic dealings and other types of dealings. So visiting someone for social reasons is the example given. But they're not addressing the point that Mr. Crowe requires them to address, which is that there shouldn't be any relationship, or the unlawful act, more precisely, shouldn't attack a relationship between the third party and the claimant at all. And we can see the same point.
In that example, when Lord Herschel says in lines 3 and 4, at the top of 139, I cannot but think that he would equally have had a cause of action. I'm wondering if it would have been the same cause of action. I wonder if he might not have had a direct cause of action in nuisance, perhaps, rather than if he's being injured in his enjoyment of his property. You might have thought that he would have a direct, that it wouldn't be a sort of parasitic claim based on the harm done to the people who want to visit his house, but rather a direct claim based on the injury to him as the property owner.
My lord, I with respect, entirely agree, and that really illustrates the danger of reading these passages which are directed to a completely different issue, reading them as shedding light on the issue before your lordships, because because there may well be, and we say there would be another tort available in those circumstances. So what's not being said is that in order to establish the unlawful means tort, you don't need any relations at all between that. That cannot be derived from these passages. That's the critical point. And the passages are dealing, as I say, with a different point. And in addressing that different point, it may well be that there is another tort which steps in, a direct tort which steps in to provide relief in the circumstances envisaged. It doesn't need to be the unlawful means tort that does all of the work. And my lord, we made that point at paragraph 89 of our page 89, in our written case at page 89. Now, the same point can be made in relation to the passage in Lord Davies' speech at page 475. So, my lords, if you have that, that's at the bottom of page 475, and Mr. Crowe took you to this, he relied on it. You see there, it doesn't appear, nor does it appear to me, that the gist of the action in those cases was that the plaintiff was a trader or exercised a profitable calling. That circumstance no doubt afforded evidence of the damage, but I suppose that if a person obstructed the access to my house or to my vessel by molesting and firing guns at persons resorting thither on their lawful occasions, I may have my action against him, though I don't keep a school or I'm not a trader, but sailing in my yacht for my own pleasure. So again, it's precisely the same point. It's not saying that the unlawful act doesn't have to attack a relationship between the third party and the claimant. At the very most, and as I say, my main point is that this is not the issue being addressed at all. It is casting comment on the nature of that relationship. And then equally, you see in Lord James's speech at page 482, this is the final passage I'm going to take you to. You see there, in the middle of the page, whatever meaning may be attached to the words interfere with, I say no ground for saying that any different rule should be applied to cases of interference with a man when carrying on his trade or business, or when he's engaged in any other dispute. And so, again, it's the same point. He's assuming an interference with a relationship. He's just saying that it doesn't have to be necessarily an economic one. So none of these passages assist my learned friend at all. Now, the other candidate was Lonhro, and I've given you our sort of punchline in relation to Lonhro, but could we please pick it up at page 549? Rather, that's the head note. If we could pick it up from page 561 in the judgment of Lord Justice Dillon. And just to reiterate, Mr. Crowe's submission is that you don't need to worry about the practice statement, because OBG is inconsistent with Lonhro, and so you can depart from OBG quite happily without any good justification. However, in order to make that submission good, he needs to show that OBG is inconsistent with something that was decided in Lonhro. And the key problem for him is that the court didn't say that Lonhro's claim based on fraudulent misrepresentations to the Secretary of State was sound in law. They said that that question should be answered at trial. And we see this at page 561 in the judgment of Lord Justice Dillon, in the middle of the page. There are many other issues which fall to be investigated, which are also, in my judgment, matters for investigation at the trial, such as whether the business interest which Lonhro claims to have had and which it claims to have been injured by the allegedly tortious acts is a sufficient business interest to support the tort which is alleged, and whether the nature of the damage which Lonhro claims to have suffered is damage properly recoverable for the tort in the particular circumstances of this case. I've no doubt at all these are all matters which must be investigated at the trial of the action. I underline that this tort is still in the process of judicial definition. This is not, therefore, a proper case for striking out. And then you have, in the judgment of Lord Justice Rafe Gibson at page 562, between letters E and F, just above letter E, there were other points urged upon the court for the defendants, which have been described by Lord Justice Dillon, but I were told that they are not such as to justify striking out this action. This is a comparatively new tort of which the precise boundaries must be established from case to case. Those points include, first, a point about intention, but secondly, the nature of the business interest by reference to which the plaintiff must prove he's been damaged, and thirdly, whether there's sufficient nexus or directness of impact and consequence between the unlawful means employed and the alleged loss. And then you have, finally, as Lord Reid reminded us, in the judgment of Lord Justice Wolfe at page 563, in the middle of the page, he expresses a reservation. He says he has two reservations. The first is whether the fraudulent misrepresentations are sufficiently direct to be capable of amounting to the interference with the plaintiff's business which is needed. I say this for two reasons. The fraud relied upon consisted of alleged misrepresentations as to the qualities of the fires and not to the shortcomings of Lonhro. But then this, it's not suggested that the misrepresentations caused the Secretary of State to take any action or to desist from any action as against Lonhro. Instead, it is alleged that the Secretary of State was influenced not to take actions against the fired. So he's expressing doubt on that point. And he says so ultimately, this is a point which is left to trial because of the uncertain state of the law at that time. So there's simply no decision on this issue. So it can't possibly be said in my submission that OBG is inconsistent with it because the point was never decided. Now, my learned friend said it was surprising that Lord Hoffman in OBG didn't say that Lonhro was wrongly decided. But the point was it wasn't wrongly decided because the point wasn't decided. That's the answer to that particular submission. Now, my lords, can I ask you to turn?
I see, Ms. Speaker, on a matter of detail, I was mistaken in recollecting that Lonhro had made a bid. I see from the facts of the case that they had wanted to, that they had given an undertaking to the Secretary of State not to increase their shareholding, and in the meantime, there had been a reference made of Affiliate MMC in relation to them and House of Fraser, and the fired bid comes in shortly before the undertaking is likely to be released.
My lord, I'm grateful. I'm standing back from this case because my learned friend says, well, this is an example, the facts of Lonhro, an example of a case which is rendered sort of unfair by the dealing requirement. But we say no. On the contrary, it's a really good illustration. These fact patterns are a good illustration of why the dealing requirement's important, especially when it comes to activities of public authorities, because if misrepresentations are made to a public authority considering a merger, and the merger goes ahead, well, by its nature, a merger is going to affect and potentially cause loss to all sorts of different actors in the market. And so it's an example. It doesn't follow from, we say that my learned friend's point, which is this is a case crying out for the dealings requirement to be disapplied. We say that's not correct. On the contrary, it illustrates why caution is needed. Now, I wanted to turn back, please, to our written case and make some submissions from that. It would be most efficient to do it that way. At page 85 of the bundle. And what we say at paragraphs 24 to 25, so I'm still dealing with the ratio argument, is that, and you have at paragraph 24, a number of domestic and Commonwealth authorities, all of which recognise that the dealing requirement formed part of the ratio of OBG. And similarly, at paragraph 25, we have referred to academic commentary, which also recognises that the dealing requirement forms part of the ratio of OBG. Now, not everyone agrees that it should have done, but there is widespread agreement that it actually did form part of the ratio, which is the point we are making here. And could I just ask you to turn up one of those cases, which is the judgment of Justice Pritchard? We refer to it as subparagraph D of paragraph 24, in the Supreme Court of Western Australia in the Hardy finance case. And you'll find that at page 1691. That's the start of the beginning of the report. And we say that the judgment is illuminating, both because it clearly shows that the judge regarded the dealing requirement to be part of the ratio of OBG, and because she considered that there was a need for a control mechanism to keep the tort within reasonable bounds, and there's discussion of that. And briefly, my lords, the facts were that that a restaurant, which you can see from page 1700, was called Spaghetti's Italian Kitchen. At leased premises, so the restaurant in this fact pattern is the third party, and it leased premises owned by the claimant, and the restaurant engaged the defendant to fit out the premises. And what happened in the course of this, there was a dispute, which we don't really need to get into the details of, but in the course of that dispute between the restaurant and the defendant wrongfully entered the premises and repossessed them, forcing the restaurant to repossess certain items and forced the restaurant to close for 2 weeks. And then subsequently, the restaurant went into liquidation. And so then what happens is the landlord, the claimant, sued the defendants for losses arising from loss of rental incomes. And they argued that the defendant's wrongful act against the restaurant had caused those losses. And just looking in a small amount of detail to the reasoning in the judgment, we see at page 1718, paragraph 702 of Justice Pritchard's judgment, the control mechanism, so it's 702, the control mechanism to keep the tort within reasonable bounds to which his lordship, that's Lord Hoffman, was referring, was the requirement that in order to be unlawful or wrongful, a defendant's conduct must interfere with the freedom of the third party to deal with the plaintiff. So like Lord Walker, she's understanding that requirement as being a fundamental control mechanism. And then you see the reference to how that was relevant to the decision, the facts of the case. And then you see at there's then a consideration of whether the tort should be applied. And the judge found that there were several reasons to be cautious. You can see that at paragraph 704 on page 1718. And pertinently, if you look at 1719, paragraph 706, the reasons to be cautious include the recognition, reluctance to permit recovery for pure economic loss, including because of concerns about indeterminacy of liability for defendants, which, of course, as your lordships will be acutely aware, is just as much a concern in English tort law as it is in Australian tort law. And then at paragraph 707, you have the further point that the tort operates in the business and commerce context, really almost by definition, and this is an environment which is the subject of extensive statutory regulation. You see that towards the bottom of the page, which is designed to maintain appropriate standards of behaviour while fostering competition. And so what's said is that the courts tread carefully in that sort of environment where statute, where Parliament has decided on the means of regulating that kind of competitive relationship. And these are both, of course, matters with which the English courts are concerned too. And as we've submitted in our written case, there are three particular features of this area of the law, which means that it is particularly important to require a close link between the defendant's wrongdoing, the wrongful act, and the claimant's loss. The first feature is that the tort permits recovery by persons other than the victim of the wrongful act. The second feature is that the one averted to at paragraph 706 of the judgment we've just looked at, which is that the tort permits recovery for pure economic loss, including, of course, pure economic loss in respect of wrongful statements, where the courts act particularly cautiously. And thirdly, the point averted to in paragraph 707, it's an economic tort, and as this case before your lordships demonstrates, the tort is liable to operate in areas governed by statute. We make these points, if you could please turn back to our written case at page 80. So we make these points from paragraphs 7 onwards, and I'm not going to rehearse the points we've made in writing, but I do wish just to emphasise a few of them. So at paragraph 8, we say that, of course, the common law doesn't seek to provide redress for all injuries resulting from wrongs. And the citation there, of course, is from the decision of the House of Lords in D against East Berkshire. And that case is also of interest because their lordships were grappling with an analogous policy choice to the one which is pressed on you by the appellants in this case. It's a different context, but it may be useful just to pick it up very briefly. So it's at page, if we could pick it up at page 973. And just by way of context, the case, of course, it was a sad case concerning claims brought by parents of young children, and the claims were brought against healthcare professionals who had misdiagnosed the young children as having been abused by their parents. And the parents claimed damages against the healthcare professionals for psychiatric harm that they'd been caused. The majority held that there was no duty of care owed to the parents. Lord Bingham dissented, and you can see if you turn to page 973 that there was a debate. So paragraphs 92 to 94 in the judgment in the speech of Lord Nichols. You can see here that there was a debate as to the nature of the control mechanism to be applied to ensure an appropriate balance between the rights of parents and the countervailing considerations, including the ability of healthcare professionals to do their jobs. And the debate was, should we have a narrower concept? Should this be dealt with under the duty of care head? Or should a duty of care be recognised, but should instead the court require take a stricter approach to breach, which was the approach that Lord Bingham preferred? And you can see at paragraph 94, Lord Nichols is saying, I can see the attraction. So this approach, which is the Lord Bingham approach, as I say, is not without attraction. is peculiarly appropriate in the field of human rights, but I have reservations about attempts to transplant this approach wholesale into domestic law of negligence. Apart from anything else, such an attempt would be likely to lead to a lengthy and unnecessary period of uncertainty in an important area of the law. And so the analogy I draw with the present case is that the appellants are barred by the dealing requirement, and a requirement which is there to confine the tort to within reasonable bounds. And what they're asking the court to do, if they're wrong on the ratio issue, is to recast the tort. You heard Mr. Crowe argue for that yesterday. And we say that invitation needs to be approached extremely with extreme circumspection, because inevitably that sort of change leads to uncertainty, and so there'd have to be a very compelling reason to do it, and that's what I'm going to come back to this point. And then you see at page 975 the point made by Lord Roger, which is the point we've referred to in our written case, just so that my lords can see the context. It's in the middle of page 975, next to letter F. When applying the test, I don't find it helpful to bear in mind, when applying the test, I do not actually find it helpful to bear in mind what is in any event obvious, that the public policy consideration which has first claim on the loyalty of the law is that wrongs should be remedied. Harms which constitute a wrong in the contemplation of the law must be remedied, but the world is full of harm for which the law furnishes no remedy. And then you see, just before we leave this case, at paragraph 104 on page 977, there's a citation from Lord Oliver's speech in Alcock and Chief Constable of South Yorkshire Police. And this really just highlights another of the 3 points I made as to the reasons for caution in this area, which is that the cautious approach taken by the common law in respect of harm suffered by persons who are not the victims of the unlawful act. So we say that this authority bears some analogy to the present in terms of the type of exercise that the appellants are asking the court to embark on. And we say further that it's relevant in this context to consider two other torts which can operate in a three-party situation, and which also can give rise to claims for pure economic loss arising from statements, because they each have control mechanisms designed to tie the loss of the claimant closely to the unlawful act of the defendants. And those are the torts of deceit and the torts of malicious falsehood. Now, Mr. Crowe was right yesterday to say that all of these torts can overlap to a certain extent, and that there's nothing wrong with that. And we agree with that submission as far as it goes. But the point that we're making is that those other torts tell you something. The control mechanisms that the common law has insisted on in relation to those other torts tell you something about what the common law regards as appropriate conditions for the availability of claims, and that this tort needs to be interpreted and applied in a way which is consonant with those principles. And so you have in the tort of deceit, which is of course the tort relied on by the appellants in this case as constituting the unlawful act. The control mechanisms are those of intention and reliance. So in particular, the common law requires that the statement is made with the intention that the claimant relies on it, whether or not it's made directly to the claimant in a two-party situation, or whether it's made through a third party and the claimant's loss is caused in that way. If it's made through a third party, the claimant's loss must be caused by its actual reliance on the untrue statement. So that's the control mechanism in the law of deceit. And in the tort of malicious falsehood, and we address this, I don't ask you to turn it up, but just for your note, at paragraph 10 of our written case, page 82, what we say is that the false statement needs to be about the claimant or his property or business. And so even if it's not made directly to the claimant, it needs to be about the claimant. And that is the way in which indeterminate liability is avoided in that tort. And so we say that without the dealing requirement in the present tort, in the unlawful means tort, there is nothing in the unlawful means tort which is adequate to guarantee a similar nexus. That's really our fundamental point in response to this appeal. Now, in relation to that, Mr. Crowe, to pick up a point Mr. Crowe made yesterday, so he disavowed the concession made by the appellants in the proceedings below, recorded by Mr. Justice Roth as to the range of possible claimants that could bring claims absent a dealing requirement. And you'll recall the points made by Mr. Justice Roth. And we would say that such potential claims would really extend to anyone that purchased the drug, including patients. But Mr. Crowe's response was to say that intention would serve as the control mechanism to exclude remote claims. So in particular, in relation to a question posed to him by your lordships, he said that generic manufacturers would not have a claim in this fact pattern because you'll recall he said at the time of the deceit, the alleged deceit, Servier had another patent that was still in force, and so it wouldn't have been possible at that stage to identify which specific generic companies would have been likely to enter the market by the time the patent expired. So that was that's why he said the concession had been wrongly made. But we disagree with that analysis because the law as it stands is that Sorrell and Smith intention is sufficient. And we saw that in the speeches in OBG, in fact, both in the speech of Lord Hoffman and in the speech of Lord Nichols. And adopting the words of Lord Hoffman at paragraph 62 of OBG, one intends to cause loss, even though it's the means by which one achieved the end of enriching oneself. So that's Sorrell and Smith intention. And in this case, in order for Servier's alleged deceit to bring about any claim, any advantage to Servier, so in order for it to bring about any gain, it needed to exclude all of the generic manufacturers from the market, any one of them. Because so for any one of them who can establish that they would have entered the market but for the patent, it would be true to say that their loss was a means to Servier's end. So, and it's no answer to that in our respectful submission to say that the defendant needs to be able to identify at the outset precisely which of the generics would have entered. If that were the law, we say that really would be arbitrary. And may I illustrate it in this way? So take the facts of Tarleton and Macaulay, the canoe case. What if there had been two competitor vessels to the Othello in the vicinity, and it was unclear to the master of the Othello with which of the two vessels the occupants of the canoe intended to trade? So they were making their way towards the two vessels. It would be arbitrary in our submission to deny liability in that case to whichever of the two vessels turned out to have suffered the loss, simply on the basis that the defendant intended to harm whichever of the two that turned out to be. And we see, in fact, that precise point was made in argument and was addressed by the Court of Appeal in the Emerald case. Could we please turn that up at page 1013. And of course, so this was a case just to locate the argument about the consequences of a cartel in air cargo services. And one of the causes of action was in the unlawful means tort. And we can pick it up, I think, just for present purposes on page 1012, at paragraph 163. And you see the argument made by Mr. Milligan QC in that case, which is the point I've just also made to your lordships. The alternative argument advanced by Mr. Milligan is that BA intended to injure every purchaser of air cargo services. That would include the freight forwarders and the shippers, but not those further down the chain from the shippers. This again assumes that it's legitimate and legally correct to treat the opportunity for any subsequent laying off of the extra cost as going to damage and not intent. So what he's saying is that the cartellists, so the airlines providing the air cargo services, that the unlawful act injured the freight forwarders and the shippers, but then that caused loss going down the chain. And then you see at 167, the critical point in our view is whether Mr. Milligan's right to say that the possibility of laying off the cost goes solely to damage and not to intent. As to the legal merit of the submission, in our judgment, the authorities demonstrate clearly that the possibility of passing on the loss goes to intent. Lord Nichols made it plain in OBG that the intent to injure the particular claimant must be the cause of the defendant's conduct. An intention to harm the claimant cannot properly or sensibly be described as a cause of the defendant's conduct if the defendant is not even sure that the claimant will suffer loss at all. So that's why the argument failed in that case. It wasn't even clear that any loss would be suffered. In this context, as Lord Nichols said in terms, it's not enough that the defendant foresees that the claimant will probably suffer harm. But then over the page, and this is the critical point, we would accept, as Mr. Milligan contends, that if a defendant intends to cause harm to the members of a particular class, but in fact only some suffer harm, then those actually damnified can sue. He gives an example, as an example a variation on the facts in Tarleton and Macaulay, positing that there were two boats seeking to trade with the natives rather than one who were affected by the firing of the cannon from the Othello. He submits that it would be absurd if the mere fact that there were two of them meant that neither could sue the defendant simply because it was not known which would bear the loss. Each boat should be entitled to sue if it could show loss. And then we would accept that in that example, there is the intent to damage the identifiable and known class of two boats. It's effectively a zero-sum gain, and the defendant will be seeking to gain at their expense. The fact that one of them could not establish loss, in fact, would not alter the analysis of intent. And then he goes on to say that's not the case because here we're more remote because it's not known whether anyone from the class would suffer loss at all. And so just transposing that back to the facts of this case, and that's why we say that Mr. Crowe is wrong to make the point he made. Here, of course, Servier could only benefit from its deceit if it kept all generic companies out of the market. And the fact, it would be absurd, we say, by parity of reasoning, to say that if one of them could show that in fact it was kept out and suffered loss, that intent should debar it from bringing a claim. That isn't the law, as the Court of Appeal has said here, and it's not consonant with Sorrell and Smith intent as laid down in OBG. So that's what I wanted to say about that particular point made by Mr. Crowe yesterday. I'm going to go on now to make a different point, but to elaborate on one of the third of the three reasons that I said that we say in our written case that the law exercises caution in this area, and that relates to the coexistence of statute in this area. And we make the case, we make the point, I don't ask you to turn it up, paragraph 12 of our written case. And of course, you've seen already that it was a point that Justice Pritchard made in the Hardy case. And we say it's a factor which weighs very heavily in the present case. The appellants, and that's for this reason, the appellant's substantive complaint in this case is that Servier was granted a patent it should never have been granted. That's its substantive complaint. But we have a patents system which provides specific procedures for challenges to patents, challenges to bad patents to be made. And they can be made either before the Patents Office or before the courts, either proactively in an action to clear the way or defensively to a claim for patent infringement. And our essential point is that the common law, the court should not permit these legislative choices to be bypassed through extending the scope of the economic torts. And a key feature here is the one that Lord Kitchin put to my learned friend yesterday, which is that the UK and the European Union legislatures, unlike the legislatures in other jurisdictions, have taken a deliberate policy choice. They've deliberately chosen not to provide for any concept of fraud on the Patent Office. And the consequence, no doubt, of that deliberate policy choice is to encourage patent applications to be made freely so that innovators aren't concerned whether they'll face damages claims if a patent office or a court later takes a different view of the facts. And we see, if I could ask you please just to pick up Mr. Justice Roth's judgment in the proceedings below, where he goes through this quite carefully. Could you please take it up from page 149? I'm just, my lord, looking at the time, and I know that you want a break at some stage, and before it's going to take me longer than 2 or 3 minutes to look at this judgment. I wonder if now is convenient, or whether you'd like me to press ahead with this judgment and take a break.
It sounds as though this is a convenient moment.
Great.
We'll adjourn then for 5 minutes. I think we're now ready to resume. Ms. Dimitriou.
Thank you, my lord. I was going to take you to Mr. Justice Roth's judgment in the proceedings below, and could I just ask you to pick it up, please, at page 149. It's really to reinforce, by reference to his judgment, the point I was making about the patent context and the need for caution in this context. And you can see conveniently he sets out at paragraph 19 a citation from Lord Justice Jacob dismissing the appeal in the proceedings on which the unlawful means taught in this case is partly based. So dismissing the appeal against Mr. Justice Pumphrey's judgment on validity. And of course, it was the judgment on validity which ended up getting rid of the interim injunction. And you see there the point that Lord Justice Jacob is making. So he says it's the sort of patent which can give the patent system a bad name. The only solution to this type of undesirable patent is a rapid and efficient method for obtaining its revocation. Then it can be got rid of before it does too much harm to the public interest. And then at 10, it's right to observe that nothing Servier did was unlawful. It's the court's job to see that try-ons such as the present patent get nowhere. The only sanction, apart from perhaps competition law, which thus far has had nothing or virtually nothing to say about unmeritorious patents, may under the English litigation system lie in an award of costs on the higher indemnity scale if the patent is defended unreasonably. And so he's saying there that it's the job of the courts to weed out bad patents. And then you see at paragraph 20 the point made the point I've just made, which is that unlike the position, for example, in the United States, there is no doctrine of fraud on the Patent Office as part of the regime, either under the European Patent Convention or in the United Kingdom. And then we see, if we could turn forward, please, in the judgment to paragraphs 43 and 44, which you'll find on page 159. At 43, this is really just to pick up the point, which has already been discussed. I'm not going to labour it because I've addressed that already. We say that the concession made by Mr. Turner was rightly made for the reasons I've given, and that the intention is not a proper means of barring claims made by, for example, generic companies, as the Court of Appeal held in Emerald. And then we see at 44, a patent is this would be, allowing a claim would be the very opposite of confining the tort within a narrow ambit. A patent is a creation of statute, and the statutory regime governing patents prescribes rights and remedies in a manner that reflects the legislative assessment of the policy issues involved. If those who suffered economic loss by reason of a patent being obtained by dishonest or reckless misrepresentations as to novelty or obviousness could use the unlawful means tort at common law to claim damages, that would circumvent that legislative balance. The very thing which Mr. Justice Jacob, as he then was, warned in the passage of his judgment in Oren and Red Box Toy, quoted with approval by Lord Hoffman, and you've seen that the approval of that in OBG, and Lord Justice Jacob expanded on this theme extrajudicially in a paper which you have in the authorities bundle, a paper he gave in November 2008 at the presentation of the European Commission's competition Directorate General, their preliminary report of the pharma sector inquiry. And that starts at page 2064 of the bundle, that paper. And if I could ask you to pick it up, please, at page 2070. And just to note that he had in mind, you'll see at the top of page 2070, that he had in mind the underlying circumstances of this particular case. And you can see that there. He explains the facts which led to the grant of the patent. And then you see in England, the patent was knocked out by the High Court in fairly short order. And my court, the Court of Appeal, upheld the result soon after. So he's got this case in mind. And then you see, if you could turn forward, please, my lords, to page 2072. You see at D, there is complaint that courts are willing to grant interim injunctions. So they are. I have little sympathy with the complaint for two reasons. First, generic companies can attack validity earlier than they do, clear the way, as I put it in one of the judgments. And that's important because it shows that there's a route for generic companies. There's a route which is laid down in the legislative, in the regulatory scheme for generic companies to tackle bad patents. Second, I've long wondered why perhaps the most affected party, the paying ultimate customer, normally a government, doesn't intervene when the injunction is sought to say it wants to be compensated if it turns out that the patent is no good and there never should have been an injunction. I'm going to come back to that point in a moment, but just finishing on this article, if you could also just turn over to page 2073 and paragraph 8, where Lord Justice Jacob asks, do competition authorities have a part to play where a patent is obviously invalid? Should a company be punished for applying for, or if not, that at least attempting to enforce such a patent? I do not know, and even if I did, as a judge, I could not comment, but the question is worth asking. I can say this: it would be seriously dangerous to have a rule that applying for or seeking to enforce a patent of doubtful validity was a violation of competition law. Most companies in the world would be guilty on that basis. Courts are the basic places for deciding on the validity of rights. And beside, the true remedy for really bad patents is their swift demise in speedy revocation proceedings brought before the patent can do any damage. So he's there, in my respectful submission, making the point that we make in this case, which is that there is a means for bad patents to be tackled. Our system, our legislature, has decided not to introduce a concept of fraud on the Patent Office. And so what shouldn't happen is that the unlawful means tort steps in essentially to circumvent that deliberate policy choice. Now, he made an important point, well, Justice Jacob, as I said, made an important point, which I'm going to come on to now, about the ability of the ultimate paying customer to seek a cross-undertaking in damages. And this was dealt with by the Court of Appeal. I think that's the most convenient place to look in order to make my submission. And so please, if my lords could turn up the Court of Appeal judgment and pick it up at page 129 of the bundle. And it's really the point of paragraph 77. And the Court of Appeal says, finally, so far as concerns the NHS's losses in the present case as a result of the interim injunction granted in the Patents Court to Servier against Appellants in August 2006, it was open to the NHS to apply to the court for Servier to be required to give the NHS an undertaking to pay damages, which the NHS might suffer as a result of the interim injunction. Such a procedure had first been suggested by Mr. Justice Jacob, as he then was, in Prime Crown. By 2006, the practice of the Patents Court, when an application for an interim injunction in respect of a pharmaceutical product was sought, was to require the patentee to give notice to the Department of Health in case it wished to seek such an undertaking, and you see an authority. This practice was formalised in all cases in October 2006 by the paragraph there stated in Practice Direction 25A, which requires the court, when making an order for an injunction, to consider whether to require an undertaking by the applicant to pay any damages to any person who may suffer loss as a consequence of the order. The 2019 Patents Court Guide, para 10.1, draws attention to this paragraph and states that when a person seeks an interim injunction, which would affect dealings in a pharmaceutical product or medical device purchased by the NHS, the court will consider whether the applicant should give an undertaking in favour of the NHS. The guide requires the applicant to notify the Department of Health by email of the application when it's made, and any order made following the application as soon as practicable. There was no reference to those procedures in the skeleton arguments or oral submissions on this appeal. Now, in other words, this practice, which has been formalised, provides that, in other words, at the very point in time, my lords, at the very point in time where a patent is used to prevent entry and therefore potentially causes harm, the court provides a mechanism by which those who are sufficiently interested in protecting themselves can achieve protection. And the patentee knows at that point to whom it will need to compensate if the patent doesn't stand up, if the court finds that it's invalid. So the system provides adequate protection to those who need it, but because the patentee is on notice, it also avoids indeterminate liability. And what we see in the circumstances of this case, and we see this in the Statement of Facts and Issues at page 39, and I'd ask you please to look at that now. So page 39, paragraph 4.1, and you'll see at at the bottom of paragraph 4.1, that in the proceedings brought by Servier against companies in the Appellants group, Appellants informed the court that it would notify the Department of Health of Servier's injunction so that the claimants could apply for the cross-undertaking to be extended to them. Now, it's unclear, we don't know why the appellants never made such an application in this case, but the point on which we rely is that they could have done. There is a mechanism there which has been formalised, which enables them to avoid loss if they think that the patent is banned. So drawing this together, the danger in extending the tort by dispensing with the dealing requirement in a context such as the present context is that it would open the door to a range of different claimants to seek damages against a pharmaceutical company, potentially years after the alleged fraud, without having engaged in any of the processes laid down in legislation for challenging the patent, and without having sought protection from the court in the form of a cross-undertaking. And we say that that state of affairs would definitely undermine the legislative choices made by Parliament in the field of patent protection, including potentially by having a dampening effect on patent applications. And my Lord Kitchen.
As I understand Mr. Crowe, he says, well, you're now developing very specific arguments in relation to a very specific area, but we're looking at this issue much more generally. What do you say about that?
Well, my Lord, I say two things about that. The first is that that Mr. Crowe rather blows hot and cold on that point himself, because he noticeably steered away from all of his hypothetical examples in his written case and said that the court should be focusing on whether there is unfairness in this case. That was a distinct theme of his submissions yesterday. And so we say he can't have it both ways. But my Lord, more substantively and perhaps more pertinently in response to your question, we say that the points I've been making in relation to this case are not fact specific. They're not fact specific in the sense that they reflect a much more general caution of the courts that you see referred to in OBG, you see referred to in the Australian case that I showed you, which is that where Parliament has legislated and where Parliament has decided how to regulate a particular field, the courts should not expand the scope of the common law to undermine those legislative choices. And so, although I am referring to the facts of this case, because the facts of this case illustrate that more general concern. And we say it's a more general concern because this is a tort which almost by definition operates in economic circumstances and is liable to interfere with competitive relationships. And that is quintessentially an area which is governed by statute. And my Lord, one further point on that, of course, competitive relationships are directly regulated by competition legislation. And there is, of course, a further possible remedy open to the appellants in this case, one which they have indeed pleaded in this case, which is breach of the competition rules. And you'll have seen that they allege in their pleadings that Servier's conduct in relation to its patent constituted an abuse of Servier's dominant position, contrary to Article 102 of the European Treaty, the TFEU, and also contrary to the domestic equivalent in the Competition Act. Now, the General Court in Luxembourg has held that Servier did not hold a dominant position. And the reason why it held that Servier does not hold a dominant position, did not hold a dominant position, is because there were other clinically substitutable medicines which perform the same function as perindopril. So in other words, other substitutable drugs that the NHS could have purchased instead. And indeed, it's presumably the risk of that outcome which led the appellants to have pleaded the unlawful means tort, which, by the way, has not been pleaded by the Welsh and Scottish health authorities in this case. But really the point that I seek to make in answer to my Lord Kitchen's question about the wider concern is that if Parliament has chosen, as it has done in the competition rules, the abuse of dominance rule, not to create liability for unilateral conduct by a company where customers have alternatives to its products, it would be wrong for the courts to undermine that choice, that balance, by expanding the unlawful means tort to achieve a different outcome to the competition rules. And so that's why, my Lord, in response to your question, I say I am focusing on the facts of this case, but really to illustrate a wider principle which goes well beyond the facts of this particular case. And my Lord, standing back from this and returning, if I may, to the question that Mr. Crowe posed at the very outset of his submissions yesterday, he asked your Lordships to ask yourselves whether striking out the appellant's claim is an outcome that the common law would wish to achieve. And he said it shouldn't wish to achieve it. But we disagree, because there is no unfairness that results, because for the reasons I've given, if the appellants were concerned about the potential impact of the injunction on the public purse, they could have and should have sought a cross undertaking. That point in time, so the time that the injunction was granted, was the very first point in time that the patent could have prevented entry and therefore caused loss. Because that was the point in Lord Kitchen.
With respect, is that not a little bit simplistic? I mean, patents may deter competitors or potential competitors from coming onto a market without the patentee actually taking the formal step of issuing proceedings and seeking an interim injunction. The protection that you're referring to was protection that was really devised by the judges, by the courts, provide at least some measure of protection in circumstances where a patentee chose to apply for an interim injunction and in that way freeze the market completely.
My Lord, that's correct. I accept that to a point, but of course there is an opposition procedure before the Patent Office. So anybody that was wanting to attack the patent could also have intervened and made their points before the Patent Office and on appeal. And so the cross undertaking isn't the only route that's available to competitors who think, or to competitors who are concerned about the effect on the patent deterring them from entering the market. And here, of course, there may be evidence of a general deterrent effect, but really the point at which the loss occurs is the point in time at which the generic company was able and was prevented from entering the market. And we do say that that generally is going to be at the point at time where they're ready to enter the market. And so they challenge the patent before the court, either by clearing the way or defensively.
Just one more question, and that's this. As I understand Mr. Crowe, he would say the particularly insidious feature of this, of the circumstances of this case, are that the patentee, it must be assumed, was aware of and deliberately kept to itself information which would have made clear that the patent was hopeless. One may not discern that from the passage in Lord Justice Jacobs' judgment, to which you referred us a moment ago, but the following passage, paragraph 20 of the judgment in which it's cited, makes clear that for the purposes of this hearing before us, it is conceded that we must proceed on the basis that there was deception, and it is deception of a kind which is not going to be apparent to any potential competitor until the validity of that patent is actually tested in court proceedings, because the patentee will otherwise keep it up its sleeve.
My lord, yes, of course that is, because this is a strikeout context. Of course, that's the premise which we agree has to be assumed against us for the purposes of this hearing. But I do come back to the deliberate policy choice in not having a concept of fraud against the Patent Office, and really the reason. Presumably one of the reasons behind that being that there may be difficult factual questions as to whether somebody actually has. No doubt there would be in this trial, because Servier, my client, vigorously contests the idea that there's any fraud. And so there would be very difficult factual questions as to whether or not the fraud is made out. And the spectre of that sort of litigation is a constraining factor, is a dampener in terms of patent application. So it's the threat of such litigation, which may or may not be well founded in any particular case, which means that that innovators are subject to a constraint. So you may have an innovator who has a patent which is extremely useful, but where there is going to be a question about novelty, for example. And such an innovator may feel reluctant to come forward and apply for the patent if they think that a claim, however unfounded, might be made as to fraud. And so really what I'm saying is that the deliberate choice of the legislature is to facilitate such claims, so that patentees, the applicants, don't need to be concerned about that sort of litigation. And there are other means for weeding out invalid patents. That's how our system operates. So that's what I would say, my lord, in response to your question. Now, my lords, I was then going to move on to consider very briefly, because in a sense I've covered a lot of the ground in relation to this point, to the question of whether, to Mr. Crow's argument that the court should depart from OBG if we're right, as we say we are, on the ratio point. And I've sought to explain, and I'm not going to repeat, that the dealing requirement serves the important function as a control mechanism, and why there are powerful reasons for retaining the requirement. And again, it's against that backdrop that the question that the court must decide is whether it's nonetheless right to depart from OBG, as the appellants invite it to do so. And our case is that it's not appropriate for the court to depart from OBG, essentially for two reasons, which I'm going to address in turn. The first is that there is no good justification for doing so. The dealing requirement does not lead to injustice or anomalies which need to be put right. And the second reason is that the alternatives advanced by the appellant are unsatisfactory. And the main alternative that they propose is that instead of the dealing requirement, there should be simply an instrumentality requirement. In other words, the OBG, the structure of the tort, should be kept as it is, but the dealing requirement excised. And as I'm going to come on to explain, we say an instrumentality, that weak concept of instrumentality, would not operate as an effective control mechanism. So taking, my lords, those points in turn, we've made the point in our written case that the appellant submissions don't engage with the 1966 practice statement. Yesterday, Mr. Crow did engage with it. He said that the practice statement permits the court to depart from a previous authority if it considers it right to do so. Of course, that is what the practice direction says. I don't quibble with that. But the question of whether it's right to depart from a previous authority is not the same thing as the court reaching the view that a different solution would be preferable. More is desired, more is required, and we see that from the authorities. I know that you'll know the authorities well, and we've summarised the points, what we take from the authorities in our written case. Perhaps we could briefly just turn that up rather than going to the authorities themselves at page 92. and it's paragraph 36. And there we extract what we say are the key principles from the leading case of Austin and Southwark, and in particular from Lord Hope's judgment. And the key point really is that there has to be a very good reason to depart from a previous authority, where, for example, if, for example, it would produce serious anomalies or other results which are plainly unsatisfactory. And so, in short, as the court said, and this court said in another case in 2016, it should be very circumspect before accepting an invitation to invoke the practice statement. And so one asks, well, what are the reasons advanced by the appellants in this case for the court departing from OBG? And they are twofold. The first reason they give is to say that the application of the dealing requirement leads to gaps. In other words, fact patterns which clearly call for redress, which would be ruled out, which are ruled out by the dealing requirement. And this is a debate which we've had in writing, and you've seen in the appellant's written case that they purport to identify examples of these gaps at paragraph 23. And Mr. Crowe didn't press these examples orally in his opening. And in fact, he acknowledged that if he couldn't succeed in demonstrating unfairness on the facts of the present case, he was unlikely to succeed on those examples. And we agree, we've addressed those examples in paragraph 46 of our written case, where we identify other causes of action which would provide relief in those circumstances. And as to his point that unfairness would be caused in the present case, well, that's a question I've just dealt with. We say that it wouldn't be. The second argument made by the appellants is that the dealing requirement is arbitrary and serves no function. And again, I've already addressed this and explained the function that the dealing requirement does serve, which is the controlling function of ensuring that the loss claimed is proximate to the unlawful act. And what I want to do now is consider the appellant's proposed alternatives to show why that function is not adequately served by the alternatives that they put forward. And I'd like to start with their main case, which is that the OBG model should be retained, but with the dealing requirement excised, leaving a weak concept of instrumentality. And the court has seen what the appellants mean by instrumentality at paragraph 9 of their written case on page 54. Perhaps we could just go back to that. And what they say at paragraph 9.1 is that what they mean, you can see from this, what they say is that the defendant's wrongful act must have interfered with the actions of the third party, and the actions of the third party must then have caused the claimant to have suffered loss. So they require the third party to actually do something. So that's different. So they would also presumably exclude the red box type of case, or the case where the defendant has simply breached the third party's patent and that causes loss to its competitor. They require the third party to actually take some action, but that action then, what you then have at that stage is that action merely has to cause the loss of the claimant. So all you've got at that stage is factual causation. There's nothing to link the unlawful act to the claimant. So that's really the difference. And so what we would say is that although just going forward in their written case to page 58, they say at paragraph 21.1 of their submissions, that the instrumentality requirement embodies a structural causal aspect of the tort, we say that their weak notion of instrumentality really doesn't achieve that, because what it does, we say in particular, their concept of instrumentality is really about the relationship between the defendant and the third party. So in other words, what it requires is that the wrongdoing must affect the third party's actions. But it doesn't say anything about the closeness of the causal connection required thereafter. So it doesn't say anything about the closeness of the causal connection required by the third party's actions and the claimant's loss. All that's required is that the third party's actions caused the claimant to suffer loss in the sense of factual causation. So there could be, on their case, on their concept of instrumentality, there could be multiple steps in the causal chain between the third party and the claimant, as long as you can show factual causation. And indeed, as I said at the very outset yesterday, in this case, there would be multiple chains in the chain of causation, multiple stages. And also, what their weak concept of instrumentality means is that the nature of the wrongdoing, in other words, why is this act unlawful? The nature of it could be completely unconnected to the loss, logically, just thematically. And it goes back to the point I was making in relation to what Lord Hoffman said. So I identified two aspects of remoteness. The first was the indeterminate liability point that Lord Lindley made, which Lord Hoffman referred to at the outset of that passage of his speech. And the second aspect of remoteness is a more thematic one, which he referred to in paragraph 59, if you recall, in the last few sentences, where he's concerned to ensure that the nature of the wrongdoing is logically connected, is connected with the type of loss, that it's not just completely separate and unconnected in a logical sense. And we say that both of those are features of remoteness, and neither of them are addressed by the weak concept of instrumentality. That's really the problem in a nutshell with the appellant's case. And we say, by contrast, the dealing requirement does address both of those things. It requires that the unlawful act committed by the defendant affects the claimant directly by attacking his or her dealings with, or putative dealings with, the third party. And so, like the Dunlop case, which you'll remember was referred to in passing yesterday, where the rival tyre manufacturers committed a trespass against the third party, which was the car company, by replacing the Dunlop, by replacing the tyres that had been fitted on the third party's cars at the trade fair. That wrongful act, that trespass, struck at the claimant, Dunlop, because it directly affected the claimant, because it directly interfered in Dunlop's relations with the car company, because they had agreed with the car company that their tyres would be on the cars at the trade fair. And so the dealing requirement thereby ensures close proximity between the defendant's unlawful act and the claimant's loss. It ensures close proximity, both in the thematic sense of the unlawful act relating logically to the loss, but also in the sense that Lord Lindley meant, that the sense of avoiding multiple chains of causation and indeterminate liability. It shuts out claims, in short, which are not proximate, including claims by persons further down the chain of causation. And My lords, this really is, I think, in a nutshell, the key issue that you have to decide. If I had to drill down and identify the point, it's this one, which is one really has to look at the weak concept of instrumentality on the one hand and at the dealing requirement on the other and the function it serves, and ask yourselves, in my respectful submission, well, you've seen what Lord Hoffman and what the majority in OBG thought that this dealings requirement was serving, and you can see logically, I hope, as I've explained it, why it serves that function, and then you have to ask yourself, well, do these alternatives that are put forward, do they do the job as well? Do we depart from this administrable tool which serves a useful purpose, a critical purpose, and put in something weaker which might have all sorts of unforeseen consequences? And we illustrate the problem with a hypothetical example in our written case. And I do want to take you, my lords, to that example. You'll recall it, perhaps. It's a version of the pizza delivery example, which you see in various court judgments and academic writing. And we set it out at page 100 of our written case, at paragraph 57, and just before I get to it, my learned friend yesterday rather urged the court not to consider hypothetical examples, and of course there's always a danger in considering hypothetical examples, but the problem in my submission, the difficulty with his submission in this context is that my learned friend is also urging the court to recast the tort, to depart from OBG and do something different. And in those circumstances, in order to consider that invitation, then I do say that it's very important that the court considers the implications of that course, not only for the facts of this case. Obviously, the appellants are really just concerned with their own case, but for the law generally and for other potential cases. In other words, what your lordships need in our submission to consider is whether the appellant's proposed alternatives sufficiently guard against claims which are remote from the unlawful act. And that's why we put forward this example. And the example is this, that you have a claimant pizza company who's in competition with a defendant pizza company, and the defendants then commit a wrong against a third party by intimidating their drivers, let's say Deliveroo drivers, riders, intimidating them to drive very quickly, drive dangerously perhaps, break the speed limits, in order to steal a march over their over the claimant, over their competitor. And the question is that a case is that a claim which should be made, in which damages should be recovered? And we say not, and we say that on the appellant's weak concept of instrumentality, it would be, because you have the unlawful act. That unlawful act causes the third party drivers to behave differently, for example, by riding dangerously, and therefore satisfies the requirements of interfering in the third party's actions. And the third parties, the drivers, take steps, they take actions which are to drive more quickly. So again, that's meeting what the appellants say is required, that the third party takes an action. And by doing that, by taking that action, what they do is they help the defendant to win business away from the claimant, thereby causing the claimant to suffer loss. And so you could easily see that you would have factual causation. And as to intention, then of course Sorrell and Smith intention may well be made out, because on this hypothesis, the defendant intended that its intimidation would have this effect. It was serving its own ends of enriching itself, but the other side of that coin was to harm its competitor. And so we say that this is in our respectful submission, an illustrative example of the difference between the dealing requirement and the weak concept of instrumentality. And we say that it would be undesirable for this type of case to fall within the scope of the tort, because quite aside from being a long way from the rationale for the tort described by Lord Lindley, the wrongful act, the intimidation of the Deliveroo riders, is far removed from the claimant's loss. The intimidation leads to the Deliveroo drivers driving quickly or dangerously, which leads to a better service for lots of customers, which leads to some of those customers deciding to buy pizzas from the defendants rather than the claimant. And at that point, you're a long way from the original wrongdoing, just as in the present case. Now, we also give another example, this time involving a public authority, in the next paragraph on page 100, paragraph 58. We say, supposing there's intimidation of a council, Camden Borough Council, and a resident, the defendant, who's an environmental campaigner, intimidates a councillor, the councillor who's in charge of setting parking rates in the borough. And as a result of the intimidation, the councillor increases parking fees in the borough. Now, on the appellant's concept of instrumentality, those who park in the borough would presumably have a claim against the environmental campaigner, because what's happened in this case is that the environmental campaigner on this hypothesis has committed a wrong against the public authority, which has caused the public authority to change its actions, in other words, to increase parking fees. And that in turn has factually caused loss to persons who park because they're paying more for the parking. And how about intention? Well, intention would be, Sorrell and Smith intention will be fulfilled too, because the very purpose of the environmental campaigner is to inhibit people from parking in the borough. And so what's the other side of that coin? It's people, it's that people are disincentivized from parking. And so we say that this illustrates the difficulty in the appellant's concept of instrumentality. And one can construct other similar examples. Take, for example, imagine you have anti-smoking campaigners and they overstate their case and commit a wrong. They overstate their case to the government and they say that a particular public health measure, such as plain packaging of cigarettes, will reduce smoking. And they commit a wrong in overstating their case, and the government introduces the measure. Well, can the tobacco companies then sue the anti-smoking campaigners in the unlawful means tort? Well, on this weak concept of instrumentality, it's likely that they could do that. And we say that these examples illustrate the dangers of allowing public authority claims of this kind, because it's quite easy to see how well-resourced companies that become subject to regulation could seek to suppress public engagement with regulatory proposals by threatening potentially expensive litigation. Just as I've said that in this case, if the appellants are correct, innovators may be more reluctant to file patent applications. It's really the same point. So, my lords, that in a nutshell is why we say that the primary alternative that's proposed by the appellants doesn't work. I want now to consider the Canadian Supreme Court case, because this is a further alternative that's put by the appellants. And we say that this model is even less apt to exclude claims that are too remote, because it doesn't even require instrumentality. And may I just show you why I say that? So if we could pick the judgment up, please, at page 861. And Mr. Crowe explained the facts to you, so I'm not going to repeat or rehearse those now. But picking it up at page 861, and you see there at paragraph 78, Justice Cromwell is explaining what he sees as the gist of the tort. So he says the gist of the tort is the targeting of the plaintiff by the defendant through the instrumentality of unlawful acts against a third party. So he says it's that conduct by the defendant which gives rise to liability, quite apart from conduct that may be otherwise actionable by the plaintiff. And I think Mr. Crowe agreed with this yesterday, but his concept of instrumentality is in Justice Cromwell's concept of instrumentality. It is different to what Lord Nichols meant in OBG, and different, therefore, to the primary case made, the primary alternative advanced by my learned friend, because what the Canadian Supreme Court here is referring to as instrumentality is not anything that the third party is doing. He's not referring to any action taken by the third party. He's referring to the unlawful act itself as being synonymous with the instrument. And so if that's right, which we say that is the correct reading of the judgment, then instrumentality adds nothing at all. He's simply using it as a descriptor for the unlawful act. So it doesn't add anything, and it's therefore much more likely to result in remote claims, more likely to. And we see at paragraph 87 on page 864, the decision there to dispense with the requirement, the dealing requirement. And first of all, I would just note that even though the court, in relation to the ratio argument, even though the court departed and dispensed with the requirement, they did find that it formed part of the ratio. So I rely on this to that extent. But secondly, in relation to the decision to dispense with the requirement, you really don't see any engagement, in my respectful submission, with the point that's now being argued before your lordships, which is the point made, first of all, with the point made by Lord Lindley, which is that the rationale for the tort, this is a tort all about dealings, it's the essence of the tort. But neither is there any real attempt to grapple, as opposed to a simple statement, with the conundrums that have been discussed in the case law as to how to exclude liability in situations that are too remote. So there's almost no recognition here that the dealing requirement serves an important function and was held to serve that important function in the OBG case. Now, what Justice Cromwell does say, he says that he prefers, you see this at the end of paragraph 87, I prefer to limit the scope of the unlawful means tort through a narrow approach to both the unlawful means component, as discussed above, and the intention component, as discussed below. So insofar as he is grappling with the point, that the control mechanism point, he's saying that happens through two other aspects of the tort. But it's important in my submission to understand and identify precisely what he means by each of those. So in relation to the first of those, the scope, a narrow approach to the unlawful means component, what he's doing and what he's referring back to in an earlier part of the judgment is the debate between Lord Hoffman and Lord Nichols as to the types of act that count as unlawful means. So is it just tortious acts, or can they extend to criminal and regulatory acts? And he's plumped for the narrower, for the Lord Hoffman approach. And then in relation to intention, what he means by intention, and this is important, is Sorrell and Smith intention. So again, he's gone for the same scope of intention as the House of Lords have in OBG, and we see that, my lords, from paragraph 95 and on page 866. So we see that we see a discussion of intention there, starting on page 866, where he identifies that in Douglas and Hello in the Court of Appeal, and this of course is referred to in the speeches in the House of Lords, the Court of Appeal identified 5 types of intention which might be relevant in this context. A, an intention to cause economic harm to the claimant as an end in itself. B, an intention to cause economic harm to the claimant because it's a necessary means of achieving an end that serves some ulterior motive. C, knowledge that the course of conduct will have the inevitable consequence of causing harm. And D, knowledge that the course of conduct will probably cause the claimant economic harm. And E, knowledge that it may cause the claimant economic harm, coupled with reckless indifference. And like the House of Lords in OBG, he says that the first 2 of these are the relevant forms of intention for the unlawful means taught. So he says that the first 2 of these species of intention represent the core intention required for the unlawful means taught. They describe cases in which the tortfeasor is aiming at or targeting the plaintiff. But what we know is that of course the second of those is the Sorrell and Smith type intention. So that this is all a piece with the majority in OBG and Allen. And so, my lords, the point that I'm seeking to make is that going back to paragraph 87, and really in my respectful submission, the flaw, the gap in reasoning in this judgment is that whereas what Justice Cromwell did was he dispensed with the dealing requirement, and he said, well, that can be that the constraining of the tort can be dealt with through a narrow approach to unlawful means and intention. But he has the same outcomes on both of those limbs as the majority did in OBG, and he's not recognising that the majority held that an additional mechanism was needed to prevent remote claims. He just simply does not grapple with that at all, and so that's why we say that this is, with respect to the Canadian Supreme Court, not an authority which we say should be followed by your lordships. And you have my point that in any event, it doesn't even include Lord Nichols' version of instrumentality. So we say that this is not that my lord should not accede to the invitation to recast the tort along the lines laid down by Justice Cromwell. That would not be, in my respectful submission, an appropriate course. Now, that takes me then to the article of Lord Sales and Professor Davies, which I'd like to address now. And really, the point that I'm going to be making, and of course, I like Mr. Crowe, I'm making these points with some degree of caution, given that one of the learned authors is on the panel. And so I hope that Lord Sales, if I misrepresent or misconstrue the article in any way, will just say so and put it to me. But I hope what I'm saying is correct. And my submission is that what Lord Sales and Professor Davies do in the article is to propose a wider approach to unlawful means, but counterbalancing that with a narrower approach to intention as the control mechanism. And I'd just like, please, to take the court to the article to explain where I see that. And it's, if I could take it up, please, at page 2108. Of the bundle, and we see here at the bottom of page 2108 the view that the dealing requirement should be dispensed with, and the reasons why the learned authors say it should be dispensed with. So those are set out at the bottom of page 2108 and the top of page 2109. But then the key thing that I rely on in the article is that the learned authors recognise that a wider approach to the unlawful act would need to be counterbalanced by a more restrictive intention test than that set out in Sorrell and Smith, which of course is the intention test we've currently got in the law. And we see that at page 210 and then 211 to 212. So starting on page 210, we see there that in relation to, so 2/3 of the way down the page, put the other way round, there will be a sufficient nexus between the claimant and the defendant to establish liability where the defendant deliberately employs unlawful means, i.e. does things which the law prohibits being done with the intention of harming in order to harm the claimant. And then we see at 211 and 212, the intention element being addressed directly. And we see this in the second main paragraph, just above halfway down the page. Before leaving this section, two difficulties with the intention element of the tort should be addressed. First, Lord Nichols in OBG endorsed the view of intention to harm in Sorrell and Smith, that a trader in a limited market who seeks to increase their share of that market necessarily intends in the requisite sense to harm their trade competitors. And of course, we know that Lord Hoffman also endorsed Sorrell and Smith. We've seen that. Secondly, and related to this, in many contexts, the Sorrell and Smith view of intention to harm seems to come adrift from a view of intention to harm in the sense of specifically targeting the use of unlawful means against a particular person, such as discussed in Rooks and Barnard. For instance, a defendant might be broadly aware of competing against others in a limited market, but have only a hazy idea who those others are, or which of them might actually be harmed by that defendant's own actions. Would that create a sufficient nexus between the defendant and the unknown claimant competitor to give rise to liability? We suggest not. A more specific intention to use unlawful means to harm a particular person should be required, using those means as the club to hit them. In Lord Devlin's language, this suggests that adoption of the Sorrell and Smith model of intention in this area is too simplistic and too wide. And then, although we contend that in this context, a narrower concept of intention to harm is the better way forward, it has to be acknowledged that if one seeks to articulate a concept of intention which is narrower than this, but is wider than the predominant intention to injure concept used for the purposes of Quinn and Leaven liability, a different source of uncertainty creeps back into the analysis. The shades of difference in the mens rea required become somewhat refined. And so, with respect, this is precisely the policy dilemma that was being grappled with by Lord Hoffman in OBG. So Lord Hoffman was saying, well, we could use a more specific than Sorrell and Smith concept of intention to guard against remote claims. But he decided that that would not be appropriate because it introduces other difficulties which appear here to be acknowledged by Lord Sales and Professor Davies. The difficulties that Lord Hoffman saw were that it would arbitrarily narrow the tort. So you would have claims which were claims which should be good claims, which would be shut out because, for example, by a more specific intention, in precisely the kind of way that the Court of Appeal in Emerald said intention shouldn't operate to shut out claims. So, for example, if you have the two ships in the canoe approaching two ships and it being unclear as to which of the ships the canoe was heading, a narrower form of intention might well exclude claims on the basis that the claimant didn't know which of the ships the canoe was going to trade with. So, and going back to the D case, the child abuse case, where you saw the courts grappling with the type of control mechanism, which is the more appropriate control mechanism. There's obviously a policy choice to be made, and it's a policy choice which the majority in OBG decided should be achieved through the dealing requirement. And the interesting thing really here is that the appellants don't grapple with this point about intention, and they don't grapple with it. They don't grapple with it because it doesn't help them. It's damaging to them to grapple with it, and it's damaging with them to grapple with it because they've pleaded Sorrell and Smith intention. And can I just show you that? So that's at page 197. And at page 75 of their pleading, and this is what they say. They say it was the case, and it was reasonably foreseeable from the point of view of the defendants, of Servier, that the elevated prices referred to in paragraph 73.3 above would be and were necessarily achieved at the expense of the claimants, by virtue of their bearing the financial burden of reimbursement payments to pharmacists and doctors for perindopril dispensed and or administered pursuant to the NHS. Accordingly, the expense caused to the claimants constituted a means to an end. That means being elevated prices achieved by the Servier undertaking. So it's classic Sorrell and Smith intention. And they could not have pleaded, in my respectful submission, a narrower, more specific intention in this case. And so really my submission is, what they can't have is some kind of pick and mix option where they go for the wider tort because it helps them, but they disregard the counterpoint to a wider unlawful act, which is specific intention, because they can't make that out on the facts of this case. And really just one further point in relation to this, which is, I just want to take you to one further article, which is that the chapter in Professor Carty's book, because she also takes an approach similar to that in my submission of Lord Sales and Professor Davies. And we see this at, the article starts at page 1867 of the authorities. So that may be, that's, yes, that's right. So that's the start of the article. And if we could please just pick it up at 1892. And you see there, so the first point I wish to just draw out is that 2/3 of the way down the page, Professor Carty says the reason Lord Hoffman gave for this extra element was to keep liability within narrow bounds. The emphasis solely on intention and causal connection was not legitimate. So she's reading the judgment in the same way that we do. So that's the first point I wish to make. And then at 1893, we see this at the bottom of the page. So this gloss only becomes necessary if the test of targeted harm is not applied in determining liability. Targeted harm, of course, suggests a very narrow intention, so that not even foresight of inevitable harm would suffice for liability. And then you see the defendant must injure the claimant through an intermediary. The question, and then over the page, targeted harm per se demands harm to the commercial link between the third party and the claimants. And so in my submission, what Professor Carty is saying here is that what she calls the gloss, the dealing requirements, the purpose of which she acknowledges, is only necessary if this test of targeted harm, in other words, a narrower intention, is not applied, which in my submission is a similar point to that in the Sales Davies article. But then what's interesting is to see how she understands that to work in practice, because what one sees at the top of page 1894 is a reference to targeting the commercial link between the third party and the claimant. So at least for Professor Carty, she's reintroducing under the intention head the need for this link. And again, we say that this is something which the appellants simply don't acknowledge because it just doesn't avail them. Now, my lords, I'm coming to the very end of my submissions, which is conveniently before the lunchtime adjournment, but about an hour sooner than I actually have. In conclusion, what we say, drawing the three threads together, is that the dealing requirement is part of the ratio of OBG. That's our primary submission. That's our first submission. You've got my submissions on the function it serves, which is ensuring that the loss is proximate to the unlawful act. And we say there is no good reason at all for the court to depart from OBG. Certainly no unfairness is caused in this case. And the alternatives proposed by the appellants are not satisfactory. So it would not be appropriate, positively would not be appropriate, to depart from OBG. Now, my lords, may I just ask those instructing me and my junior if there's anything that I've missed? I'm told not. I don't know if my lords have any questions. I can see the time. I'm very happy to answer any questions now or after lunch, but I didn't have anything else I wanted to say.
Well, we won't necessarily hold you to that. Shall we adjourn just now? And if anything occurs to you, or indeed to us, during the adjournment, then we can raise it with you at 2 o'clock.
Very kind, thank you.
Very well, thank you.